So welcome to the week 11 of our Introduction to Intellectual Property, the survey course, Law 726. This will be in the first week of the patent law section of the course, which is week 11. And I'm very honored to have my co-author of the casebook we're using as well, Professor Jay Kesan, Workman Research Scholar and Professor of Law at the University of Illinois Urbana-Champaign College of Law. Welcome, Professor Kesan. It's great to have you. And he will give us a little tour of patent prosecution, patent litigation, and also tell us a little bit about how to enter into the world of patent practice today. You've had a very interesting background, Professor Kesan. Jay, if I may. How did you enter into the field?
Shubha, it's a real pleasure to be here and to share a few moments of patent practice and patent prosecution, patent litigation with your students. Thank you very much for inviting me.
It's our pleasure. Yes, thank you for taking the time.
Yeah, of course. So like a lot of patent practitioners, I started out as an engineer. I was an electrical computer engineer, and in fact, all my first 3 degrees were in electrical and computer engineering. Finished with a PhD from the University of Texas at Austin, electrical computer engineering, and then I actually worked as a research scientist, at the IBM Thomas J. Watson Research Center in New York.
Not too far from here?
Yeah, not too far from here, at Yorktown Heights. And in fact, I'm an inventor. I'm of 20 plus patents, and I've continued to to be sort of involved in the innovation side of things. Mm-hmm. And then that's how I really got interested in IP when I was at IBM, and I began to realize the importance of IP and patents in particular. And that's what prompted me to go to law school. And then I went to law school at Georgetown University. I practiced at Penny and Edmonds. I was federal appellate clerk, and then after my Penny and Edmonds days, I joined University of Illinois at Urbana-Champaign, and I've continued to be an academic, but also very much a member of the profession. I've now been a registered patent attorney for well over 20 plus years, and I continue to be engaged in patent practice professionally.
Yeah, that's amazing. And your work at Penny and Edmonds, was that in patent prosecution, or was it a mix?
So I did patent prosecution early on, and then I started doing more patent litigation. That's one of the things that we should talk a little bit about as we go on, is how the nature of the patent practice has changed. And in those days, in the 1990s, the patent practice was very much patent firms. And so the best patent practice was not the GP firms in those days. Actually, the GP firms started getting in the late 1990s and 2000s, when they realized that patent litigation was lucrative. And that's when they opened their so you very much had in the 1990s, it was the Penny and Edmonds, it was the Fish and Neve, it was the Fish and Richardson, it was the Finnegan Henderson, it was the Brinks Hofer. These are all the people they were all IP firms. They were all they were not GP firms. And so one of the advantages that you had in those days was that you could do both patent prosecution. In fact, the firms encourage you to do patent prosecution early on in your career as having a nice foundation. And then if you're interested, you continue in patent prosecution, or you can do litigation, and you're always given the chance to do both. And I think there's some real benefits to that.
Yeah, interesting. Were you with Penny and Edmonds in the Bay Area, or in DC?
No. So Penny and Edmonds, so they had 3 offices in New York, DC, and in Menlo Park. And I was based out of the New York and the Washington, DC office.
Oh, nice, yeah.
But I, of course, being in electrical computer engineering, I spent a lot of time in the Menlo Park office as well, because they had a lot of Bay Area clients.
Fascinating, yeah. And so right now, I guess one of the implications would be, do you think patent practice is still geographically constrained, or can students nowadays find a good, healthy patent practice in other parts of the country rather than sort of the tech centers?
That's a good question. And I still think that there are about 6 to 8 areas where you have a large patent practice. So I would say New York, Boston, Washington, D.C., and Virginia has always been very important because that's where the USPTO is, that's where the Federal Circuit is, and that's where the ITC is, and of course, Eastern District of Virginia District Courts as well. So that's always been a prominent hub. And then Houston and Dallas are both quite active, so is Chicago. And I would say out in the West Coast, I would say San Francisco, and you have a decent patent practice even in LA, and then biotech down in San Diego, and then again for biotech and IT up in Seattle as well. So those tend to be sort of the big areas.
And I suppose one of the big changes from the 1990s is that we have these satellite offices for the USPTO. Do you want to talk about them just very briefly and how they may have changed practice?
Yes, indeed. And that is a development in the last 3-4 years where now you have a very active Dallas office, you have a very active Detroit office, and you have a very active Silicon Valley office. And these
Denver.
In Denver as well. And you have these satellite offices where you have examiners, and you also have nowadays PTAB judges in those places where they basically don't even have to come to Washington, D.C. for hearings. So things like are actually being held in these satellite offices. So it's very much so, and it was a nice economic development initiative by the USPTO to put these offices in these places.
No, that's very helpful to give us some of the background, and we can return to some of the practice pointers towards the end of our conversation. Maybe, we probably put the cart before the horse. Students are probably wondering, what is patent prosecution? What is patent litigation at this point? But I think you've whet their appetite. So how would you describe what patent prosecution is? We're going to discuss it during our synchronous class meeting later this week, and we'll also discuss it when we get into the elements of patentability. But what exactly, as a practice matter, is patent prosecution?
Patent prosecution is basically the administrative process. It really has nothing to do with prosecution in a criminal law sense. So this is really you're prosecuting an application before the U.S. Patent and Trademark Office. So there's 2 steps typically before you get to the USPTO. You usually have your client or some inventors who you're working with will come to you with an invention. And then you typically will do a patentability search. So you do a search for prior art, and you'll come to some conclusion of what aspects of this invention are novel and non-obvious, and those are the requirements for patentability. So, new, useful, non-obvious. Once you sort of finish the search, and then you get a more detailed disclosure of the invention, and you work with the inventors to do that. And that then becomes your patent application. You go back and forth on drafts, you work on figures, you work on examples, you work on claims, and then that patent application is then submitted to the patent office, and that sort of launches the patent prosecution process. So then once the application is filed in the patent office, you have technical people, they're patent examiners. They're usually examining applications in the particular field of your invention. They may be lawyers, but they do not have to be lawyers. They're typically people with bachelor's, master's, or PhDs, depending on the technology area. They're very well qualified typically, and they have had tremendous experience. So if you were to go and file an application on some genetic sequence for developing some particular biologic, then you're virtually guaranteed to have a PhD who's going to look at this, and he's looking at these kinds of biologics in a certain specific sub area, like, for example, immuno-oncology. And he may have been looking at that, and that's all he's doing. That's his job. And then
there might be a team of examiners, right?
Right. It could be a team of examiners, but usually there is a primary examiner, or there's one level even below, a junior examiner, and then there's a supervisory examiner. It's called, often referred to as a SPE, a supervising primary examiner. In patent parlance, they call them SPEs. So yes, their work gets checked by more experienced examiners, and then and of course, if you were to say you want to file an application for a new kind of circuit or a new kind of modulation scheme in a wireless communication circuit, then you would have these people who are schooled in wireless communication systems and who understand coding and modulation and all those things very well. So then it goes to them, and then they will do their own search. Now, you are required in our patent prosecution rules to have there's something called a duty of candor. So you have to disclose, material prior art. But assuming you do that, they're not going to be limited by that. They're going to go do their own search, and then they're going to put out something called an office action. And when they put out an office action, they'll tell you, they'll go claim by claim, and they'll tell you this claim is rejected because it doesn't satisfy 35 U.S.C. Section 101, or it's not new because of this reference, and so it doesn't satisfy Section 102, or it doesn't satisfy Section 103 because it's obvious in light of certain combinations of references, or Section 112, so on and so forth. So once you get this office action, then you respond back and you prepare a formal response to the office action where you basically state step by step every rejection, why they're right or wrong, so on and so forth. And usually you have 2 rounds. You pay for an initial search and 2 rounds. That's what your initial filing fee is really for. So you get to go 2 rounds, and then at that point, you make a decision. Hey, should I, file another continuation, like a request for continuing examination, or do I file another application, or do I abandon it, or do I take the claims that have been allowed? And I say, let's take these claims that have been allowed and let that patent go through issuance, and then I will then continue to argue about these other claims. So that's the process by which the patent issues. In addition, there is the ability for you to do interviews with examiners. This is, of course, at the discretion of the examiner, but very often, you might have, after you've gone a round or 2, and you think that, hey, let's have a sort of a abbreviated discussion back and forth where I can point to specific things and kind of satisfy the examiner. And so that's the interviews. And then, of course, you have appeals. And you have appeals from the patent examining core to the Patent Trial and Appeals Board. So broadly, this process is the process by which an applicant or a patentee gets a patent, and that patent acquisition process is called patent prosecution.
Okay, interesting. And just to add a little bit more detail, the patent examiner has to be a member of the patent bar, but need not be an attorney, need not be a member of a state bar as an attorney. And the person who's representing either the inventor or the applicant or both, what bars do they typically have to be a member of?
So basically, you have to be a patent agent at least. If you're going to represent somebody before the USPTO, you do not have to be a patent attorney. In other words, you don't have to be a member of any state bar. You can just be a patent agent. Examiners, when they
Which means you take the patent bar, just to
Which means you take the patent bar.
Pass it, yeah.
And that's all you need. That's even today, that's all you need. Examiners, when they start out, very often don't even have not even passed the agent's exam. Usually the fresh examiners, they basically sort of on-the-job training. And then some of them may take the agent's exam, some of them, they spend a long period of time, and so on and so forth. So it's not an absolute requirement.
But they're being supervised, of course, by somebody who is a member of the patent bar. Right? Yeah.
Yes, and they are being supervised. And then there is, many of them typically after a short period of time, they do take the patent bar because the examining court does tend to be a little bit of a revolving door. It's a very good experience. So people do go there for a few years. It doesn't mean people don't stay there for their whole careers. They're actually among some of the best paid people in the entire federal government. So you will meet examiners who have been there 20 years and wonderful careers. Very satisfied, moving up the government scales. But a lot of times people will be there for 2, 3, 4 years, and then they will move to the private sector. So they take the patent bar and move to the private sector.
The private sector, they might even go to law school, or they might have their own representing clients as a patent agent. Yeah.
Exactly.
Yeah, okay.
They might choose to be on the outside, and once they've finished their period where they basically can't do anything for a period of time, coming out of the government, then they might very well do that. And many of them indeed do go to law school in the evening as well, or sometimes go to law school full time. Yeah.
And so I think you used the phrase, just to clarify, examining corps, C-O-R-P-S, the body of examiners. But of course, there's also a court. In fact, there's several courts. Let's talk a little bit about that. You mentioned the PTAB already, the Patent Trial and Appellate Board, which is a recent body. Let's go back to a more traditional, typical court, a federal court, which arises in the context of litigation. So we've talked about patent prosecution, and the other main area of practice is patent litigation. How does that relate to prosecution?
It's interesting because the patent system itself is really, you can think of it as being in 2 stages. You've got the first stage, which is the patent prosecution, patent acquisition stage. And once you get a patent, then it's not self-actuating. And that's only your first stage. Then you have to go to a federal district court because the federal district courts have exclusive jurisdiction on patent matters. And so you then move to the second stage. And in the second stage, you as a patent owner can bring a patent infringement claim against somebody for patent infringement. So it's really a 2-stage system. It's important to understand, however, that the 2 stages are very much related to each other. So in the second stage, which is the patent litigation stage, everything that happened in the first stage can be revisited. So it's not just infringement that is at issue in the second stage. In fact, in the second stage, you can go back as a defendant and raise all the issues related to patentability. And you can say, hey, you sued me on this 124 patent, referring to the last 3 numbers in the patent number, because often the way patent attorneys refer to patent numbers. And the defendant says, hey, you've sued me on this 124 patent, but I believe that this 124 patent claim that has been asserted against me is invalid. Why is it invalid? It's invalid because it doesn't satisfy the requirements for patentability, 101, 102, 103, 112, the basic statutes in Title 35 of the US Patent Code. So the second stage allows you to revisit everything in the first stage again as a defendant. And you can also argue that you are not infringing the claim. So the argument there is, even if the claim is valid, I don't fall within the scope of the claim and I'm outside, so I'm not infringing. So one of the really important things that is easy to miss in the patent system, and this is perhaps one of the most important things as a student of patent law to keep in mind, is that because this is a 2-stage system, patent prosecution, patent litigation, as a plaintiff in the second stage, as a patent owner and as a patentee in the second stage, you have to win on both validity and infringement. You have to be able to prove that your patent is both valid and infringed.
In the second stage.
In the second stage. As a defendant, however, it's not and, it's or. So that is where the system means that as a defendant, you can say either the patent is invalid or I'm not infringing. Right. So you have two ways to escape as a defendant, whereas as a patent owner, you've got to prove A and B. You got to prove both validity and infringement. And as a alleged infringer, you can basically say it's either invalid or it's not infringed. So that's a really kind of it sort of tilts the scales a little bit.
That's a good point, yeah. And I think it's worth mentioning, you may have mentioned already that in the second stage in litigation, the patent owner does have the presumption of validity. Is that accurate?
Yes. So in the second stage, as Professor Ghosh mentioned, you are a patent owner, but the Federal Circuit has said that because you've gone through a process of examination, there is something called the presumption of validity. And what the...
it's in the statute though, right? It's not just the Federal Circuit. So yeah.
That's correct. Actually, what the Federal Circuit, it is in the statute. Yeah. What the Federal Circuit has done is that they've said that presumption of validity translates into the amount of evidence needed to invalidate a patent. So what they've said is a presumption of validity means that a preponderance of the evidence is not enough. You need clear and convincing evidence to invalidate the patent. So in the second stage, the defendant in a patent infringement lawsuit has to prove invalidity by clear and convincing evidence, but he does not have to prove non-infringement by clear and convincing evidence. He just has to only prove that by preponderance, as with any civil action. Yeah. So that is a little bit of a difference.
And how does that burden compare with what's going on in the prosecution stage, the first stage?
So in the first stage, you again, it's just a preponderance of the evidence. So is it when you're in the process of getting your patents allowed, it's really just, is it more likely than not that your claim is valid now?
And the burden is on the applicant there.
Correct.
Yeah. Correct. Okay. Good. Yeah. Who becomes the patent owner, hopefully, in the second stage. Yeah.
Exactly. And so this is often referred to as a sort of as you can imagine, this is called an ex parte process. The patent prosecution process is an ex parte process because the patent owner is on one side and then the agency is on the other side.
Patent applicant,
the public's interest. The public's interest. And then in the second stage, it's more inter partes, more like traditional civil litigation, A suing B.
And that's worth emphasizing because when we're talking about patent litigation, you do have to be a member of a state bar. You don't necessarily have to be a member of the patent bar to represent a client, either a patent owner or alleged infringer. Is that correct?
Correct. So it's a very good point. If you want to practice in the world of patent litigation, then you do not need to be a member of the patent bar, although many of them many of them who are practicing are members of the patent bar, but it's not required. In fact, a substantial number of patent litigators don't have technical background. They just have an interest in science and so on. In fact, it's important to keep in mind a related point here that's very important. The typical federal judge is not a member of the patent bar. The typical federal judge doesn't even have a technical background. So this is not like the examining core, like a patent examiner who does have a technical background and you can sort of talk back and forth your technical details. Whereas with a federal judge, you really have to make the technology and the claims and the infringement case accessible to the federal judge. I think there's only one federal judge. Last time I checked, Judge Godbee in the Northern District of Texas and Dallas, who's a member of the patent bar. Otherwise, I don't know of any other federal judge who is, in fact, a member of the patent bar. So all the other 770 odd federal judges, none of them are, members of the patent bar. This is also an important point to keep in mind that just because you don't have a technical background, you should not be discouraged from entering the world of patent practice, because the patent litigation world is wide open to you.
Mm-hmm. No, absolutely. And if you like to litigate, if you like to represent business clients, if you just like litigation, whether it's business or not, I mean, a lot of the defendants may not be business clients. I mean, in the traditional sense, it's a really rich area. We'll talk about the federal circuit. I mean, one of the interesting things about the litigation side is you do have the federal circuit, which is a specialized appellate court for patent appeals. So the district court, the litigation can originate in any district court where there's jurisdiction, federal district court where there's jurisdiction, but all the appeals have to go through the federal circuit. Do the judges on the federal circuit, are they members of the patent bar typically, or what is their background?
So that is another very interesting aspect of patent practice, which is the United States Court of Appeals in the Federal Circuit. Remember my two stages, the patent prosecution stage and the patent litigation stage in the federal district courts. Both of them you appeal up to the same appellate court, which is the Court of Appeals in the Federal Circuit. So if your patent is denied, you have internal appeals within the PTO, and then you can go up to the Federal Circuit. And if you're here in one of the 94 federal judicial districts, you don't go to the regional circuit. You don't go to the First Circuit or Fifth Circuit, etc. You go to the Court of Appeals in the Federal Circuit, which is in Washington, D.C. So all appeals from all the 94 federal judicial districts end up in the same appellate court, which is the
intermediate appellate court, right below the U.S. Supreme Court. Yeah,
exactly. And currently there are about 12 judges there, and there are a decent number of them who do have a technical background. You know, the judges like Judge Ken, Judge Moore, Judge Lurie. You know, these are all people with a technical background.
Judge Newman.
But then you also have a significant number of others who have no technical background whatsoever. And yet, you know, many of them are seen as being, terrific patent judges. So I think it once again reinforces the point that you don't need a technical background. You just need really a desire and inclination to understand scientific and technological material. And so, you know, a majority of the judges in the Federal Circuit don't have a technical background. Many of them did not even practice patent law before they were appointed.
Yeah, no, this is very helpful. It reinforces some of the things we're talking in class. I think we can unpack this a little bit more. I'd like to. So right now we've said that if you're a member of the patent bar, you can represent a client in front of the US PTO to prosecute a patent, to basically file the application, and hopefully that will mature into an actual patent when the applicant becomes the patent owner. And then you've got litigation practice, where the patent owner can sue infringers, starting in federal district court and going up to the Federal Circuit on intermediate appeal, and then to the US Supreme Court. Now, there's one other wrinkle that might be worth unpacking, and as you've described, the patent prosecution is interesting, but that's largely kind of a technical practice in the sense of you're basically trying to convince the patent examiner that your invention meets the technical requirements for a patent. And then litigation is really a traditional kind of litigation practice with a deeply technical, factual background that you have to deal with. But the other aspect is the administrative practice, that if you're an attorney who's interested in administrative law, those skills do come up both in prosecution and litigation, but they also come up when you're maybe challenging a rejection by the patent office. And they may also come up in the context of the PTAB. So for the students out there who are starting, another area that's really important for them to study, I think, is administrative law. Right. And so we do have some time now. We're doing well in time. This is very informative. Could you talk a little bit about, for example, if you do get rejected by the PTO, what is the avenue in court or for appealing that rejection. And then we also have the PTAB, which fits into that a little bit, but also can be a sort of a supplement to litigation, but from an administrative side rather than from a federal court side. So that's a lot to unpack, I know, but maybe you can help us with that as well.
Yeah, absolutely. Let's go back to how when you file the patent, you're dealing with patent examiners and you try to get your patent allowed. If your patent is rejected, or if some claims are rejected, there is an internal appellate body within the US Patent and Trademark Office called the PTAB. That's the Patent Trials and Appeals Board. It used to be before the AIA, before the AIA was passed in September 16, 2011, the same body was called the BPAI. So in some of your readings, you will see this referred to as the Board of Patent Appeals and Interferences, BPAI. Today, we don't have interference practice anymore as we move to a modified first to file system. So today, that same body is called PTAB, Patent Trial and Appeals Board. So you can take an appeal from the examining court's rejections, and you will have a 3-judge set of administrative patent judges. And so these are ex parte appeals. So now in front of the PTAB, it's you on one side, but the examiners on the other side. So you both write your briefs. You can write your brief, the examiner will write his brief supporting why he is correct. And then the PTAB decides that. Now, once the PTAB makes a decision, let us suppose the PTAB says, no, we're not going to allow these claims. At that point, you can go to judicial review. And at that point, again, you have 2 paths. If you want to introduce more evidence, then you can go to federal district court in the Eastern District of Virginia. And typically, at that point, applicants want to introduce something like an expert. One of the main reasons why they might go to federal district court, to introduce more expert testimony to support why the patent should be granted. If you believe the record is fine and you don't need any additional supplementation by way of evidence, you can go directly to the federal circuit that we just talked about. So you essentially go from patent examiner to PTAB to federal circuit. So that's the way the prosecution piece of it works all the way to the federal circuit. And by the way, if you get rejected there, you can go and appeal the federal circuit's decision all the way to the Supreme Court. If you believe that a patent should have been granted, and by the way, this is not so unusual.
Right.
We actually do have a decent number of cases that start in the patent office that end up in the Supreme Court. For example, early on in your readings, you might read a case called Diamond versus Chakrabarty. It's an example of where Diamond was actually the commissioner of the patent office at that time. And so it went all the way to the Supreme Court.
Bilski versus Capos as well, yeah.
Bilski versus Capos and Alice versus number of issues related to patentability that go all the way to the Supreme Court. And then on the patent litigation side, let us say the patent owner A sues defendant B. Remember what I told you, that the defendant B can argue that the patent is invalid or that the patent is not infringed. Now, he can argue in district court that the patent is invalid, and then he has to put up with the presumption of validity and clear and convincing evidence standard, or he can go to the PTAB. So this PTAB, it's important to understand, it's kind of straddling between the stage 1 and stage 2. So when you're in stage 2, you, the defendant, B, can go and file a petition at the PTAB arguing that the claim that had been asserted against them is invalid. And then now you're once again facing the preponderance of the evidence standard at the PTAB.
So the PTAB can arise, just to give a very basic understanding, One is if there's a rejection by the examiner, that would be an appeal there from the applicant. But the other is once the patent is granted, somebody can then go to the PTAB to challenge the patent. Again, this goes back to a point you made before about how patent prosecution is an ex parte proceeding. It's between the applicant and the examiner. There are some instances when parties can introduce prior art, but it's not really an inter partes, it's ex parte really. It's not the applicant against the world, it's the applicant against the examiner.
Correct.
But once the patent is granted, the PTAB can also be appealed to by the world or by anybody who has, it's a pretty broad basis for standing, right, to bring a challenge in the PTAB, right?
Right. So in principle, at the PTAB, any third party can challenge an issued patent. And there are three different mechanisms. There is a inter-parties review, the so-called IPR. There is the post-grant review for 9 months after patent issues. It's called the PGR. And then you have the CBM, which is the covered business methods mechanism. So there are three mechanisms that you can use to challenge a patent. Now, interestingly, what we have seen since the America Invents Act is that the vast majority of challenges to issued patents, by vast majority, I mean well over 85% of all the challenges to issued patents at the PTAB are defendants from federal district court. So basically, in my simple example of patent owner A suing defendant B, it's the defendant Bs of the world who bring a lot of issued patent challenges by filing petitions at the PTAB. Now,
and the remaining, just to clarify, the remaining 15% are not in litigation at the moment, right?
Correct.
They may be anticipating litigation, or they may be challenging the patent on maybe a public interest basis or some other basis.
Right. So I had done an empirical study a few years ago, and we actually found that roughly 87% of all the PTAB petitions were from district court defendants, and the remaining 13%, a significant fraction of them were actually from life science biotech area, where there were all these competitors who were very interested in these patents that had issued, and in the life science space, each patent tends to be more valuable for reasons that we can discuss a little bit later. And so these people were motivated to challenge these patents of their own.
Yeah.
Because they fully expected to be impacted by those patents, even if they had not been sued yet in court.
And so on the whole, what is your finding as far as the success of these challenges in the PTAB? Is it 50-50? Is it more favorable to the challenger? What is your conclusion about that, your insight about that?
Right. So it's really, it's a little bit of a mixed bag. And let me explain. So the way the process works is there's a petition that is filed by the defendant. The patent owner gets to file what is called the preliminary response. And then it goes to this 3-judge panel who decide whether to institute the petition or not. In other words, do you meet a threshold requirement that there's a reasonable likelihood that there's at least one challenge claim that is likely to be invalid? So if you meet that threshold, then you go to the second stage. Now, at the first stage, as a patent owner, this is your best chance to basically convince the PTAB that, in fact, there is nothing in the petition that really challenges these claims. And you the PTAB simply needs to deny institution of the IPR or PGR or so on. Now, very often, what is the case is because there's a number of claims challenged, you have situations where some claims are instituted, some claims are not instituted. So it's not the case that all the challenged claims are going to get instituted.
Right.
And if the patent owner is able to get a few claims allowed that are still likely to be strongly infringed, then even if the inter-parties review has been instituted, the patent owner is pretty happy with the result because he still got a few claims that are infringed that survived a challenge. So the first stage, it's easier for the patent owner in the sense that there's a greater likelihood of prevailing. And very often, if there are some claims that are instituted, then you move to the second stage. But if there is a certain number of claims that are not instituted and where the infringement case is strong, very often the parties will settle. Because at that point, the defendant says, well, I have really given it my best shot at killing this patent, and I still have parts of these patent claims that I am probably very likely infringing, so let me work out a settlement. And usually then the matter goes away. But then if you go to the second stage, at the second stage, once the petition is instituted, then you have a full-blown multiple stage process leading up to a hearing. And in the process in the second stage, the chances of the original claims still being found to be valid are not that high. So in the second stage, the petitioner has a greater chance of succeeding.
The challenger to the
challenger. The alleged defendant in federal court who's now become the petitioner at the PTAB. Now, what is even the playing field a little bit on the second stage nowadays is that the PTAB has in more recent times made it easier to amend the claim. So that has been a little bit of a sort of evening the playing field mechanism, where now in the second stage, the patent owner doesn't get the original claims, but he might be able to amend some of the claims and get those through an IPR or PGR or CBM, and then now they've got valid claims that have survived a PTAB review. The disadvantage of doing that is that if you amend the claims, you cannot collect past damages. The standard for collecting past damages with amended claims is pretty stringent.
Right.
So what you say is, okay, I give up past damages, but I've got enough life left in the patent. Let me amend the claim, and if I can get that allowed, then that'll put me pretty strong.
And the PTAB, does it treat challengers who are in ongoing litigation differently from challengers who are not in litigation? I mean, is it no noticeable difference or?
So I've actually, been the counsel of record in more than 20 IPR CBM proceedings, and every one of them arose in the context of a litigation. But we did not find in our empirical study, we did not find a specific difference. And having said that, the PTAB is acutely aware, in my experience, that most of these cases, almost 90% of these cases, are occurring against the backdrop of litigation. So they tend to be acutely aware of that. So as a result, you will find that other defendants who want to join a IPR petition are given an opportunity to join. And so the PTAB is aware that there are ramifications in the proceedings before it of what is happening in court.
And once you have a finding that one challenger has brought that's against the patent owner, it then can bind other potential infringers, right? There's a sort of a res judicata type effect there.
Correct.
Yeah, even in
correct. Exactly. But also, other defendants may join the petition just so that their lawsuits against them are stayed by the district.
Yeah. And that's one point I wanted to raise as well, that when you do have the pending federal litigation, it is stayed. So to see what the result is of the PTAB. So that's fairly interesting.
Yes.
And so
so it's a cost-effective way to challenge a patent.
No, we're going to talk about that. We've talked a little bit about the SAS case and some of the interesting administrative law rulings that are coming out. It's a very fascinating and rich area. And so thank you so much for enlightening us and giving us some perspective on that as we do our discussion. I think we're trying to go pretty deep, even though we're going to only spend a very short time on patent law, but there's just a lot, but there is a certain intuition to it. It's complex. I guess it's complicated, but not really that difficult in the sense as you described it. There are these discrete stages, there are these discrete courts, and so forth, and it's important to sort of understand that. In order to appear before the PTAB, just to complete the picture, you have to be a member of the patent bar or not. Do you want to talk a little bit about that?
Yes. Typically the lead counsel in a case is a member of the patent bar and is required to be registered to practice before the PTO. But you can be a counsel. If you are a member of the bar, you can ask to be admitted in that particular matter, in that particular petition. So you can file what is called a pro hoc vice application, for the purposes of this matter. So you can file a pro hoc vice application, and the PTAB will, unless there is some objection from the other side, they will allow you to appear for the purposes of that. But they do expect the lead counsel to be present, and the lead counsel is a patent attorney. The pro hoc vice applicant cannot simply proceed all on their own. They will need a patent attorney on their team.
It's a team. Yeah, it's a team effort. That's important to keep in mind. And of course, invention itself can be a team effort often is. So you have multiple applicants, multiple inventors. It's a pretty interesting dynamic process. So thank you. I mean, this really complements our co-author, Richard Gruner, who spoke to us at the beginning of the course in week 1 about commercialization. And so we see as an IP attorney, and then more specifically as a patent attorney, there's so many areas of practice on which you can build. From Professor Gruner, we got a sense of transactional practice in terms of commercialization. And Professor Kesan has told us a lot about administrative practice, litigation practice, as well as kind of a pure technical practice that comes up as you're engaged in prosecution. So thank you for taking the time to discuss with us. Let me give you again the final word in terms of, or final several words, however you'd like, in terms of what types of takeaways you'd like our students to have from the IP survey in general, and then from the patent portion.
Indeed. Just a couple of things that come to mind that I want to really leave you with. One point I did mention before, and it's worth repeating. If you want to be a patent attorney, then take the time to try to, in your careers, do some patent prosecution and some patent litigation, regardless of where you end up. Even if you're a patent prosecutor, knowing how these things that you're doing before the patent office will be viewed by the courts is important. And even if you're a patent litigator, knowing how to autopsy a file wrapper to understand what happened at the patent office is going to be important as a litigator. So one point I would say, which I find a lot of my students tell me, oh, I wish I did a little bit more of this or that. After they've kind of gone down one path. And so I urge you to try to get that opportunity. The second thing I want to tell you is, the rules and the statutes and the court's decisions and so on have continued to change because patent law is a very active area. But the patent attorney's role has really not changed much. And here's what I mean. Your high-level role is really to exercise good judgment on behalf of your client. So, if you are a prosecutor, you really have to advise your client properly. Should I go get a patent? Should I really keep this a trade secret? Should I actually not patent this and I should actually publish this because I'm trying to, this is, it's not that valuable and I want it defensively. Protecting and so on and so forth. So, you want to exercise good judgment. Similarly, if you're a litigator, which patents to bring, which claims to bring against which defendant, whether it's a method claim or apparatus claim, which venue that is favorable for for your client and where you get personal jurisdiction over the defendant. So these kinds of exercising good judgment, should you file abroad, should you file in the US, all of these kinds of questions, these high level questions remain the same. So, it's still very much about advising your client properly and exercising good judgment. And then the second piece, of course, is actually performing the task. Writing the patent application, writing the response, actually taking the deposition, actually drafting the complaint. That's the actual task. Yeah. And so that's kind of the, it's important to keep in mind the high level role that you're playing.
Yeah, and that's what's exciting about IP practice in general and then patent practice in particular. I think I should emphasize, we do have an externship opportunity at the USPTO that many of our students take advantage of. And also in general, there's the Giles Rich Moot Court that sometimes their students participate in. And I think the USPTO also has a claim drafting competition that you may be familiar with as well. And our students have participated in. So there are lots of opportunities within law school and then beyond to develop a very rich and interesting career. So thank you again for taking the time. And I really appreciate it. And I want to thank you also on behalf of our students.
Thank you so much. I hope this has been helpful. And Professor Ghosh, thank you for inviting me.
Yeah, thank you.